Ready? All right.
You're good.
Ladies and gentlemen, thank you very much for coming. This is the first in our Practice in a Flash series of CLEs. I'm Gabriel White. I'm a member of the CLE committee. We want to first thank Jones Waldo for being kind enough to host these for us and provide the videography services. Also want to thank and introduce for you our presenter today. Today's topic is going to be on the basics of family law. Now, as you may have heard, this Practice in a Flash series is particularly designed to help attorneys who may be starting their own practices, starting a new practice, learn the very basics of how to start and get running a family law practice. And so Jared is the perfect guy for that topic. He graduated from the University of Utah Law School in 2005. He's practiced family law ever since, been involved in a number of cases, large and small, and he's very knowledgeable in this subject. He's currently an associate at Parsons, Bailey, and Latimer. And so if you'll join me, please welcome Jared Hales.
Thanks, and it's good to be here this morning. What I'm doing in this presentation is kind of starting out from a spot where I assume that nobody's handled a family law case before. And so if you have, and some of this material is repetitive or seems too basic, I apologize. But hopefully it will be of some use to some of you as you think about taking a family law case. I'm sure that as you've started your legal careers, that's probably the #1 area of law people ask you about. You know, do you know a family law attorney? Do you know a divorce attorney? It seems like that's what people want to know. I think that's why a lot of people go into different areas, is they don't want to have to handle those kind of cases, especially for family members and friends. So let's go ahead and start. And I appreciate the introduction from Gabriel, but let's go ahead and start with some of the basics of handling a divorce case. The first issue is jurisdiction. For jurisdiction in a divorce case, there are residency requirements. And they're different depending on whether there are children involved or not. So for jurisdiction just for the divorce, there's a requirement of 3 months of residency in the state and county for one of the parties for the divorce. So you may have one party that's in California, one party that's living in Utah. The party in Utah can file if they've lived in Utah for at least 3 months. Now, if there's children involved and you're going to have issues of custody and support and parent time, there's a 6-month residency requirement. There has to be established that the children have lived in Utah and been residents for 6 months prior to the court taking jurisdiction. As you can imagine, that could lead to an awkward situation where maybe one of the parents has been here for 3 months, but the children haven't been here for 6 months yet. The court would not be able to go forward on the child support and custody issues until there's 6 months of residency. Now, the court can, under statute, take limited emergency jurisdiction if it needs to over children prior to the 6 months. So once you've established jurisdiction, the next thing is to go through the issues that are pertinent to any divorce. The big one usually is custody. Custody and parent time. So physical custody, you'll hear your clients come in and talk about, hey, I want sole custody. Well, you have to talk to them, what does that mean to you? Because there are different types of custody. There's physical custody, which is which parent actually has the children overnights. And for purposes of establishing custody, the court looks at overnights. So for example, if you had a client come into you that said, look, what my husband and I have been doing is I have the children all day from 6 in the morning until 10 o'clock at night, and then I drop them off at his house and they sleep overnight. the husband would actually be considered the custodial parent because he's the one that has those overnight visits. And so with physical custody, there's basically three different types of physical custody. There's primary physical custody, which is kind of your traditional, one parent has the children for most of the overnights. There's joint physical custody, which is usually thought of as 50-50 custody, but it can actually be less than 50-50 custody. It's if one parent has the children at least 111 or more overnights during the year. And so you could have a situation where basically one parent has the children a third of the year and the other parent has the children 2/3 of the year, and that would technically be considered joint physical custody. The third type of physical custody arrangement is called split physical custody, which is pretty rare, and that's where one parent, say there is 2 children involved. One parent has one of the children for most of the time, the other parent has the other children for most of the time. And so that would be considered split physical custody. Now the difference that it makes on the custodial arrangement, it affects child support and the amount of child support that's ordered. It also affects the children's expenses. If parties have joint physical custody, it's understood that they will share more of the children's expenses. There is no presumption. Oh, the other type of custody is legal custody. Legal custody is the ability to make decisions for the children. And so if parties are, and there can either be sole legal custody or joint legal custody. Joint legal custody has become more and more the norm in my experience, where parties will share the decision-making power over the children. In a case where the parties are going to share joint legal custody, there needs to be a parenting plan in place. And so if you have a client that comes to you that says, look, my spouse has filed a complaint for divorce, she's asked for sole legal custody, I would like joint legal custody, you would need to file with the court, along with your answer or counter petition for divorce, a parenting plan, a proposed parenting plan. And the parenting plan lays out the specific terms of how the parties will share joint legal custody. The decisions that would need to be made on a joint basis would be listed in the parenting plan. So for example, if the parties said, look, we're going to share the medical and educational decisions affecting the children, that would need to be in the parenting plan. There's no presumption of either joint or legal or physical custody. The court must consider, though, whether joint legal or physical custody would be in the best interest of the children. In determining, so the court, when they go to make a determination on physical custody for the children, there are a number of different considerations that they take into consideration. Some of those are by statute. For example, Utah Code Section 30-3-10 says specifically that the court should consider the past conduct and demonstrated moral standards of each of the parties. Which parent is most likely to act in the best interest of the child, including who will allow the children more frequent contact with the other parent. The extent of bonding between the parent and the child, and any other factors the court considers to be relevant to the children. Remember that the overall consideration for the court in determining custody and parent time is the best interest of the children, what's going to be in the best interest of the children. And again, those factors that I gave you specifically are listed in Utah Code Section 30-3-10. Now, say that the parties are in disagreement over who should have custody of the children. There's a number of ways about going and trying to convince the court that your client should have physical custody or joint physical custody. You'll always have your witnesses that can say, oh, I've witnessed this parent with a child, they seem to be the better parent, therapists, doctors, things like that. Something that's commonly used in disputed custody cases are custody evaluations. Custody evaluations are specifically mentioned in Rule 4-903 of the Utah Rules of Judicial Administration, which lays out the qualifications that a custody evaluator must have. Now keep in mind, with a custody evaluator, they are specifically appointed by the court. And so the court will issue an order appointing the custody evaluator when the parties request the custody evaluation. A custody evaluation is going to typically run between $3,000 to $10,000. And the court in their custody evaluation order will say how the upfront cost of the custody evaluation will be paid. So it may be, look, respondent, if you are requesting a custody evaluation, you're going to pay 100% of those costs, and will reserve the final allocation of those costs for trial. The custody evaluation order usually also requires that the parties start the custody evaluation, that the evaluator start it within 30 days of the order being entered. The order also says that the fact-finding portion of the custody evaluation would be completed within 120 days. And what that means is the custody evaluator, they're going to go out, they're going to observe both parents with the children, they're going to talk to the children's teachers, doctors, a therapist. They'll talk to peripheral witnesses, maybe a neighbor that has seen a parent interact with a child. This is all part of their fact-finding and fact-gathering. They also have the ability, if they need to conduct mental evaluation testing. Most custody evaluators, at least in Salt Lake, are PhD psychologists and have the ability to do that. One other thing I forgot to mention, when you do have a client that comes in asking about a divorce and there are children involved, you need to remind the person that there is a required divorce education class for parents that's taught through the bar, and it's taught in every district of the state at the different courthouses. That schedule is on the state court website. And this is a class that, it's a divorce education and an orientation course where parents will go in. I believe the class is 2 to 3 hours, but it's taught by someone that talks about, how you talk to your children about the divorce, how you can, how it's better to get along with the other parent in trying to present a united front to your child or your children in situations of divorce. I've had a lot of clients that have come in that said, I'm not the one that needs the class, she's the one that needs the class, or he's the one that needs the class. I say, well, that's great, you still have to take it or you're not getting divorced. And 9 times out of 10, they actually come back and say, I'm really glad I took that class. I realized that maybe I was saying some things to the kids that I shouldn't have. That, I didn't realize I was involving them in this, or the effect it would have on the kids if I involved them in this. So make sure when you're meeting with a client for the first time, you inform them of that requirement. Okay, let's talk about parent time a little bit. There's a minimum parent time schedule that's outlined in Utah Code section 30-3-35. This is the parent time schedule everybody's familiar with, 1 night a week and every other weekend. This is the minimum. The court's usually not going to do less than that unless there's instances of abuse or a real threat that the child could be in danger if they were to spend that much time with a parent. The minimum schedule specifically is 1 evening per week from 5:30 to 8:30 p.m. Unless the parent's available to pick the children up from school, their parent time can start sooner. And then every other weekend beginning Friday at 6 p.m. through Sunday at 7 p.m. If the children are less than 5, there's a little bit different schedule. That's found in section 30-3-35.5. Now keep in mind, this is the minimum parent time schedule. Some judges like it, some judges like to get away from it. Typically, you know, if you have your clients agree on a parent time schedule, it may be more than this. But this is the minimum schedule per statute. There's also found when you're dealing with custody issues, sometimes the issue of relocation comes up. So for example, you've gone through the divorce, you've gotten your client divorced, there's a decree of divorce that says, you know, dad's going to have parent time this one evening a week and every other weekend, mom has custody of the children, and then all of a sudden mom says, hey, I'm getting remarried and moving to Arizona. This relocation statute, again, unless the parties agreed otherwise in their decree of divorce, the court's going to look at this relocation statute to determine what happens with the children. It applies specifically if one of the children, or if one of the parents moves 150 miles or more away from their residence that's specified in the decree of divorce. It says that the relocating party needs to give at least 60-day advance written notice before they move. Sometimes that's not possible, but they need to try to give the 60-day written notice. The notice needs to say what the parent time schedule will be, and it also needs to say that the parent will not interfere with the court-ordered parent time. Now within this relocation statute itself, it talks about, it gives a minimum parent time schedule. Again, the parties might agree differently, the court could order differently, but there's at least this minimum parent time schedule. And what it says is, depending on an odd or even year, the parents will alternate Thanksgiving and winter break. They'll alternate spring break and Thanksgiving break, or spring break and fall break, excuse me. And then they'll each have half of the summer in consecutive time. So one's going to have the first half of the summer, the other's going to have the second half of the summer. Additionally, the non-custodial parent would be entitled to 1 weekend per month at that parent's election and expense. The statute talks about who pays for the travel. The relocating party, again, unless the parties agree otherwise, the relocating party is going to pay for the spring break, fall break visit. They're going to pay for the Thanksgiving, Christmas visit, and then the parties would split 50-50 the cost of the summer parent time, the expense for that. The next issue to deal with as far as children is child support. Child support is based on the child support tables that are located in the Uniform Civil Liability for Support Act that's found in Utah Code Section 78B, Chapter 12, or 78B, Section 12, Chapters 101 through 403. So, child support, for child support, the courts are going to look at the incomes that both parties have, and that's income from one full-time job equivalent to 40 hours a week. And so you could have a situation where, you know, one parent has their regular 40-hour job, and then a couple nights a week they deliver pizza and earn some extra income from that. For child support purposes, and it's different for alimony, but for child support purposes, the court's going to take the income from the one full-time job. Now, where you can run into some issues with figuring out what a person makes, and especially this seems to happen more and more in the economy that we're in now, is a party that makes wildly different income from year to year. So, for example, say you have a real estate agent that in 2009 made $250,000 that year. And then in 2010, she had a really bad year and only made $100,000. In 2011, she made $175,000. In my experience, the court will often average those years out to come up with an income of what that person's average income is for purposes of calculating child support. Now, say that you have one parent who's earned income and the other parent hasn't worked or has been out of the workforce for a few years. The court can impute income to the other parent, which means they can say, look, you've got the ability to work. Whether you choose to or not may be one thing, but we're going to impute income to you. And so when we calculate child support, we'll have one parent's income here. We're going to impute this other income to you over here to get the child support figure. The imputation of income is, like I said, income that the court believes that party has the ability to earn. So the court can look at the person's work history, their education, what they're skilled to do. There could be a vocational assessment where you have a professional that comes in and says, look, this person has a college degree in history, these are the type of jobs they've worked in, these are the type of jobs they'd be qualified for, and this is what the job market's like now. Based on the vocational assessor's expert opinion, we believe that the person could make this much per year. Now, there are instances where the court won't impute income, but the statute says that they should at least impute minimum wage at full time to a party, but there are instances where they won't impute income. That includes if the cost of childcare would be approximately the same as what the person could make. So we're not going to send a parent to work to earn minimum wage if what they're earning is less than what they're going to pay for childcare. The other instances are when a parent's physically or mentally unable to earn minimum wage. If the parent's engaged in career or occupational training to get basic job skills, or if there's unusual emotional or physical needs that children have that would require the parent to provide full-time care for them. So what you'll do is once you figure out the incomes of the parties, and we're looking at just gross income for the parties, is you'll look at, again, if you get on the Utah Court's website, there are different child support calculators, depending on the type of custodial arrangement you have. And so if you look at, say for example, the sole custody worksheet calculator for calculating child support, it's pretty easy to do. You're going to go in, you'll put in the number of children involved that are minors, the gross income of both of the parties, hit calculate, and it spits out what the child support number should be. In most cases, it's not difficult to figure that out. Like I said before, some of these cases where you have a parent that has earned vastly different income from year to year, that can be a little tough to figure out, or if a parent needs to be imputed income, or if a party owns his or her own business. But on these child support calculations, you'll have the sole custody worksheet, the joint physical custody worksheet, or the split custody worksheet, depending on the type of custody the parents are going to share. On the joint custody worksheet, you would enter the number of overnights each parent's going to have, because that adjusts the child support amount that a party will have to pay. Also, a parent, if they've been divorced before, they have a child from a prior relationship, and there's an order for them to pay child support or alimony, they would get credit against the child support that they'd be ordered to pay in the new case. Other payments for children that are required to be in any decree of divorce are how the medical insurance and the cost of the children's medical expenses will be divided. This is in Utah Code Section 78B, Chapter 12, Section 212. When you do a decree of divorce, it must say that the children will have insurance provided for them if it's available to a parent, and how the medical expenses will be divided. Usually, parties are going to split the cost of the children's portion of the medical insurance and the children's portion of any out-of-pocket medical expenses 50-50. On figuring out the medical insurance, that's done on a per capita basis. And so what we look at is, say that they are going to be on the mom's employer-provided health insurance plan, and that her insurance, she pays $500 a month, and there are 5 people on that insurance plan. Say it's the 4 children and her. You divide the total monthly policy by the number of people on the plan to get a per person amount. So that would be $100 per person. And then the parties would share the kids' portion. So 50% of the $400. Hopefully that was clear. So, the statute governing the cost of medical expenses, sharing medical expenses and insurance, it specifically says that once a cost for the children is incurred, and so say dad takes the child to the doctor, there's a $30 copay, he's responsible for 15 of it, mom's going to be responsible for 15 of it, he pays the $30, the statute says he should give mom proof of the payment within 30 days of incurring it, and she should reimburse him within 30 days of receiving that. A practice pointer is, I would put in any decree of divorce or the agreement of the a stipulation of the parties that it shall be provided within 30 days and it shall be paid within 30 days. Because a lot of times what you have happen is one parent holds on to those receipts for a year because mom and dad are getting along pretty well, and then something blows up and all of a sudden mom says, hey, you owe me $1,000 for these out-of-pocket medical expenses, and dad says, why didn't you give those to me before? I don't have $500 laying around to give you. And so I would make it really clear in there that it shall be provided within 30 days and shall be paid within 30 days. Daycare, work-related daycare, or education-related daycare is the same. The parties are typically going to divide that, split the cost of that 50-50. And so that would be, not the babysitter so that one parent can go out on the town, but daycare that's related while that parent's in work or at school. The other issue dealing with the children is who gets to claim the children on taxes? Who gets to get those tax credits and deductions? Those can be worth a lot of money to a party. The statute says that the court's going to look at who's providing more of the support. I will tell you in practice though, it's been my experience in 99% of the cases that I've been involved in, that parties typically end up agreeing to just divide the right to claim the children. So if there's one child involved, we're going to alternate that right. Mom's going to take it in odd years, dad's going to take it in even years. If there's more than one, say there's 3 kids, mom gets 2 kids in odd years, dad gets 1 kid in even years, and we alternate. That's typically what happens in practice. A lot of times parties will agree that a parent has the right to purchase the right to claim the children on taxes from the other parent. So what that would involve is, hey, maybe claiming the right maybe having that right to claim the children on taxes is going to be worth $2,000 to mom, but $5,000 to dad. So dad has the right to say, look, I will give you the $2,000, let me claim the kids on the taxes this year. Now that's only going to happen if it gets put in a decree of divorce, so keep that in mind. So we talked about the children, who gets the children, how the children are paid for, what's paid for the children. The next is basically what happens with our stuff and is this an alimony case? So in deciding whether it's an alimony case or not, keep in mind there's no tables for alimony like there is for child support. There's no calculation where we put in husband's income, we put in wife's income, calculate it, spits out a number for alimony. We don't have that. So there are specific factors the court must consider, and those are found in Utah Code section 30-3-5. And what the court will look at is if you have one parent that's claiming that's asking for alimony. They'll look at the financial condition and need of the recipient spouse. And so they're going to look at, okay, what has this person, what do they need to live on from month to month? And, in looking at those needs, it's not, I've lived in $1 million home, shop at Nordstrom all the time, have a gym membership, or have a membership to the country club. They'll consider that, the court will consider that an expense. So that would go under financial need. They don't expect the party to necessarily cut down on every little thing to basically get by. So they'll look at that need, and legitimate needs will come up with a number. Say it's $6,000 a month. So the spouse claiming a need for alimony, I've got a need of $6,000 a month. Next, the court's going to look at the recipient's ability to meet that need. So I need $6,000 a month. My net income is $3,000 a month, and I'll also be receiving $1,000 a month in child support. So I'll be bringing in $4,000 a month. I've got a shortfall of $2,000 a month. So that would be the need, is that $2,000 per month. Then the court looks at the ability of the other party to pay alimony. Again, they're going to look at that party's expenses, and they're going to look at that party's income. And so, say that the other party has expenses of $5,000 a month, including child support, and net income of $7,000 a month. That person has $2,000 extra. They'd be ordered to pay alimony to the other party. Sometimes you will see, especially from attorneys that don't practice family law all the time, they may go in and argue, look, court, you need to just equalize the parties' incomes so that it's fair. Each party should be receiving $10,000 a month. So that means you may be giving my client a big chunk of alimony. There's specific case law, and I can't remember the case off the top of my head, so if you want it, you can email me and I'll send it to you. There's specific case law that says the court doesn't just equalize income. They cannot award alimony in excess of what the person's need is. So if you have an attorney that's arguing, look, my client has a need of $8,000 a month, but your client makes a ton of money, so we want to just equalize and have your client pay $10,000 a month. You say, no way. That's equalizing income. The court won't do that. Now, if there's not enough to go around, and there's a shortfall on both sides, then the court may find it appropriate to equalize the incomes. But they won't give alimony in excess of what the person's established need is. And so those are the three factors: need, ability, and the need of the paying party, that the courts primarily will look at in alimony. There's some other factors listed by statute that are given less weight, but nonetheless the court may look to. Length of the marriage. Now keep in mind, when you're handling a case where alimony is involved, that the court won't order alimony to last beyond the length of the marriage, except in very rare circumstances. Will they ever do that? The court will also look at whether the recipient spouse, or the spouse that's claiming, that's asking for alimony, whether that spouse has custody of the children. They'll look at whether that spouse has worked in a business owned or operated by the other spouse. They will look, so a person, you may have a situation from time to time where one spouse is listed on the payroll of her spouse's family business, making $6,000 a month, but really not doing anything more than, going down and cleaning up the office every once in a while or something. Basically being overpaid because it's a family business. The court will take that into account in awarding alimony, specifically in the person's ability to meet their own. They'll also look at whether the recipient directly contributed to an increase in the payer's skill. And so, for example, wife works hard to put husband through medical school, husband graduates from medical school, and all of a sudden is, in love with one of his classmates or, the nurse at the hospital or something. The court can take that into consideration in their alimony award. In determining alimony, the court can consider all income. And so beyond that 40-hour-a-week job, if a person has income from a trust that they receive, if they have a second job, the court can consider all those things and whether to award alimony. If it's a short-term marriage, when there's no children involved, the court can also consider just restoring the parties to the position they were in before. And so that, and not awarding any alimony at all. Alimony terminates upon the death, remarriage, or cohabitation of the person receiving alimony. By way of just practice pointer, I've noticed over the last few years, especially since 2008 when the economy took a downturn, I get a lot more clients that say, look, prior to last year, we were really living high on the hog. For 20 years, I drove a BMW, had a membership at the country club. That was my lifestyle. It's only been the last 6 months that things have had to cut back because my spouse's business went south, or they lost their job. One practice pointer I would do is when you're negotiating alimony, and the other side saying, look, my client simply can't pay that alimony, can't sustain the client in that lifestyle. You may consider putting in any stipulation and settlement agreement the amount that the person has a need for, but recognizing that the other party doesn't have the ability to meet all of that need. So you may want to say something like, petitioner has a need for $10,000 a month. However, the respondent only has the ability to pay this much in alimony. That way, say the economy turns around and the person, things start going well for them again and start making the kind of money they made for 20 years during the marriage, you could go back to the court on a petition to modify and say, look, my client had this established need, and he's now got the ability to pay it, or she's now got the ability to pay more in alimony to meet that need. Otherwise, what happens a lot of times is the need won't be established, and when you go back to the court to say, look, they can make more money now, the court says, well, how do we know what the need was at that time? And you've got a proof problem. So anyway, just one practice pointer. The next is in dividing property. What do we do with the stuff? We figured out what we do with the kids, alimony, what do we do with their stuff now? There's little statutory guidance on how property should be divided. There's case law that also says there's no presumption of just a 50-50 division of property. The court has to specifically make findings on how property is divided. Now, although there's no presumption, that's what the courts typically end up doing, is dividing property 50-50. Keeping in mind that that's marital property, so property that comes in, that the parties obtain during the marriage. With the exception of if one party inherits or is gifted some property, that would remain that party's separate property. With some exception that I'll talk about in a minute. And so any premarital, inherited, or gifted property is going to remain the separate property of the person that receives it. Personal injury awards are a little bit different. Typically what the courts do there is, if there's money that's received by one spouse in a personal injury award that's to replace income, the court would look at dividing that. If there's money that's received for pain and suffering that's not replacing income, usually the court's going to award that amount to that party because it was their pain and suffering. The exception to premarital, gifted, or inherited property remaining separate is when the property is commingled. And this is actually an issue that comes up on a pretty regular basis. So let me just give you a couple examples of possible commingling of property and how the courts approach that. Example one, say that wife before the marriage has a brokerage account, gets married, and after marriage, both parties start contributing money into that brokerage account. They're taking money out of it, spending it on marital expenses. So money's going in and out regularly. And then they go get divorced, and wife says, well, look, I've got this brokerage account that I had before we got married, and I want it as my separate property. The court's going to look at, okay, has it been commingled? So has it lost its separate character? Can we track what was premarital money versus what came in and out? In that case, it's going to be pretty tough because there was dollars going in, dollars going out. Both were contributing to it, both were benefiting from it. In example two, say it's the same brokerage account, but after the marriage, it's a really big brokerage account, but after the marriage, neither party's contributing to it, except for maybe it's the husband's brokerage account, and from time to time he gets a family gift of $10,000 and puts that in there. But the parties do take money out of it to spend on family expenses. In that case, the court's still likely to find that that is his separate property because it's never lost its character. There's no confusion about whose money was going into it. It maintained its separate character. These issues of commingling can be difficult. Another example could be a house that somebody has before marriage. You got a house before marriage. When you get married, both of them contribute to finish the basement on the house, which increases the value of the house. To make that argument that it hasn't been commingled, you've got to go in and say it was worth this much at the time you got married. Yeah, we finished the basement, so maybe part of the value of the house should be backed out as a marital asset to divide, but this amount is still, I should get credit for premarital value on that. And there's just no hard and fast rule on that, so arguments both ways. There is quite a bit of case law that can be used to convince the court on your position, but no hard and fast rule there. In dividing personal property, again, the court's going to look at the different issues involved there, and they won't necessarily just say, look, it's 50-50, but they have to make specific findings on it. In my experience, what the courts usually will do is order the parties to make a list of the property, divide it themselves. If they can't divide it, then bring the list to the court, and the court will figure out how to make a division of it. It's been the rare case where I've had cases I've taken to trial that personal property, the things from the house was actually an issue. Usually the parties are going to be able to come to an agreement. I'll take the couch from the basement. You take the couch from the living room. The other personal property that would be divided would be financial accounts. Specifically, retirement accounts are dealt with in a specific way. Most retirement accounts are divided by what we call the Woodward formula. Woodward versus Woodward is a famous case in Utah on the division of a client's or of a party's retirement account. So the Woodward formula that came from that case is that the court will take the total number of months of service of the marriage as the numerator. So, let me explain this in a better way. Husband is worked at General Electric for 30 years. Husband and wife have been married for 20 of those 30 years, but he's worked there the entire time. So what you'll do is you'll take the total amount of time that he's worked there she'll get credit for the amount of retirement funds that were contributed and the gains on those funds during that 20 years, but not the entire 30 years. And so what the court does is they will enter what's called a qualified domestic relations order. You'll hear it referred to as a quadro. And that order tells the plan administrator of the retirement account, here's how you're going to divide it. You know, there was 240 months of service at your company during the time they were married. Wife is entitled to 50% of that, and that's how it will be divided. The quadro also allows a party to avoid any early withdrawal penalties. What happens is the plan administrator receives the quadro, and unless the other the other party that's getting the funds elects to just be paid it directly, they would roll that money over into an IRA. If you have a client that comes in with a federal pension or a military pension that falls under that, you can't just do the Woodward formula for that. There's a specific set of rules. To be honest, when I have that happen, there are a couple attorneys in town that do a lot of those that work up by Hill Air Force Base. I turn that work over to them because it's not worth the time it takes me to re-educate myself, when that comes up once a year or every other year, because it can be a little bit complicated and they're not very common. So, on one practice pointer on dealing with dividing retirement accounts, usually if you're dealing with a bigger company that has a plan administrator that you can speak to, often they will give you a sample quadro that they already have. You want to use that one. Also, if they will review it for you before you submit it to the court, you can save yourself a lot of time and money by having the plan administrator approve it, then submit it to the court. Because the court is usually going to just sign it. And what will happen sometimes is, you don't submit it to the company first, you submit it to the court signs it, you send it to the company, the plan administrator says, look, this isn't compliant with what we require, you gotta do it different. And sometimes they can be difficult and not tell you exactly what's wrong with it, and then you're just wasting tons of time trying to figure that out. So if you can get it approved by the plan administrator first. The next issue would be any debts incurred during the marriage or presumed to be marital debts. The court will often divide debts on the ability of the parties to pay those debts, or sometimes they'll say, look, both these parties incurred and benefited from the debts, we're going to divide them equally, and each party can be responsible. When you are writing up a decree of divorce or a stipulation, and you're talking about the debts, you'll often use language that party A is taking this debt and will hold the other party harmless from that debt. Party B is going to take these debts and hold the other party harmless. So there are these hold harmless provisions that you'll do and that you'll see. The thing to remember is that is not binding on any creditor. The credit card company, the auto financing company, the mortgage company, doesn't care what the decree of divorce says. They've got a contract that both your clients have signed, or both the parties have signed, and they're going to hold them to that contract. And so it doesn't necessarily get your client out of paying that obligation. They can still be sued and collected on for that. So that's something to remember in dividing those kind of properties. The other thing you're going to include in any decree of divorce is a name change provision. If you have a client that would like to be to go back to her maiden name or her former name, you can put that in there. I often put, the petitioner should be restored the use of her former name, Jane Smith, should she choose to do so. That way, if you have a client that later on says, look, I really would like to have my driver's license say my name rather than my husband's last name. They don't have to go through the process of doing a formal name change. The decree of divorce would allow them to do it. We have a few minutes left here. I want to talk real quickly about what happens when you get that initial case. You get the spouse that comes in that says, I need a divorce. I want him out of the house, or I want her out of the house. I've been a stay-at-home parent, and so I need some support as well. What do we do? So you can file a motion for temporary orders, which are orders the court will put into place until a final decree of divorce is entered. Keep in mind that the court has continuing jurisdiction in the divorce. They can change the decree of divorce after it's been entered. They can change temporary orders before a decree of divorce has been entered, depending on whether circumstances change. So temporary orders are governed by Rule 101 of the Utah Rules of Civil Procedure. What will happen is you'll file your motion for temporary orders, and if you have a case that's in the 1st, 2nd, 3rd, or 4th district of Utah, you will schedule a hearing in front of a commissioner instead of a judge. Commissioners commissioners hear a lot of preliminary family law issues, other than the trial, and so you'll be in commissioners most of the time when you're in a family law practice. You'll be in front of the commissioners. They operate under a different rule of timing, and that's this Rule 101. And so it's different than if you are filing a lawsuit over a broken contract between business partners. The timing on when things are filed, when things are responded to is different. So what happens is you'll file your motion for temporary orders, you'll schedule a hearing with the court, and that hearing has to be more than 14 days after the other person's been served with the motion for temporary orders. The other party, upon receiving that motion, then has to file, and that's 14 calendar days. The other party then has 5 days. They can respond and file a counter motion at least 5 days before the hearing. And it gets a little tricky because that's 5 business days, not 5 calendar days. And then the other party can file a reply to the response and counter motion. So go into Rule 101 and look at that. I know me saying it I think I'm confusing myself a little bit, quite frankly, but just keep in mind those timing issues there. When you file a motion for temporary orders, you must file a financial declaration with proof of income if child support or alimony is an issue. If you have a client that brings in a motion for temporary orders, or you're on a case and opposing counsel sends you a motion for temporary orders, and it doesn't, they're asking for however much in child support, and there's not a financial declaration, and there's not a pay stub, then you can object to it. And the other party then must provide that information. There is a new initial disclosure rule that's going into place in November. It's Rule 26.1, and it's specific to family law cases. And it requires from parties in family law cases to give a lot more in their initial disclosures, with the idea that, look, if each party's getting the bank records and proof of income, it's a lot more likely that the parties will just be able to settle. I mean, if I have proof of debts, income, and bank records, that's really all I need to know to settle a case for 90% of the cases that I have. And so you'll want to look at that Rule 26.1 that's effective November 1st and determining what you have to provide from the outset when you take a divorce case. Real quickly on modifications of decrees. So the decree of divorce has been entered. You have a client that comes to you that says, look, I would like to change custody. I'm not happy with what the court did, or I'm not happy with what I agreed to, I want to change custody. In modifying custody after a decree of divorce has been entered, there's a two-step process. First, you have to show there's a substantial and material change in circumstances. So, that would not include, I changed my mind, I don't like the agreement that I came to, so I want custody now. It would have to be something big and unforeseeable at the time of the divorce. The second thing the court is going to look at is the best interest of the children. And again, you can ask for a custody evaluation, you can present evidence that another parent's been abusive, or the child will be better off in your care for whatever reason. Keep in mind that if you file a petition to modify custody and try to go in and change custody on a temporary basis, the court will do that only if the parties have been doing that, so to ratify basically a change that's the parties have already been living by, or if there's a substantial chance of harm to the child. Otherwise, the court's just going to leave the order in place until trial on the issue or agreement of the parties. That kind of scratches the surface with family law, the nuts and bolts of family law. See that we're out of time, and so maybe we should end the video, but if anybody has questions they want to come ask me, then feel free to do so. I appreciate your attention and being here today. Thank you.
And before we finish up, just wanted to let everybody know next Tuesday we're going to be having the next CLE in this series. It'll be held here again at Jones Waldo at noon. The presenter will be Matt Mitten of Jones Waldo, and it'll be on the fundamentals of wills, trusts, and estates. And you can register for that the same way you registered for this CLE. Well, thanks a lot for coming, everyone.